So how is it that we create a valid security interest? Well, two things have to happen before that valid security interest is created. And the first is the execution of an agreement. To create an agreement, a contract with the lender that defines and creates the security interest. Remember, security interests are going to be used to secure the payment of an obligation. That's what the bank is interested in. It's not interested in the property that you're pledging, other than would the sale of that property satisfy the debt, the underlying debt that you have occurred. Now, security interest on the property used as collateral can be narrowly defined. We could say one specific vehicle, here's the vehicle identification number, or we could make it very broad, all vehicles that I own now or may own in the future. So a security interest can include items beyond the initial collateral. So that's the first step, the creation of an agreement. This agreement is usually a written agreement. It's signed by the borrower or by the person extending the secured interest. The second step is what we call attachment. This is when we attach the security interest to the property. And this is achieved when value has been given, the debtor has rights in the collateral, those rights usually including possession and usage, and a security agreement, which have been executed by the parties. Now, an oral agreement is allowed in some jurisdictions. However, from a best practices standpoint, you want to make sure that the security agreement is in writing, signed by both parties. The statute of frauds does not require the writing in this instance. Nevertheless, it is the right thing to do if you are a creditor and if you're a borrower too. Now, once those requirements are met, the creditor's rights attach to the collateral. So just to state it a different way, attachment requires three things. The extension of value, the giving of value, something in value has been given in exchange for the borrower's granting of the security interest. The debtor must have rights in the collateral, meaning the debtor must own or have some interest in the collateral, some property interest. And the debtor has authenticated a security agreement that we drafted in the first step that describes the collateral. Once attachment occurs, attachment gives to the creditor an enforceable security interest in the collateral. And at that point, the creditor becomes a secured creditor, meaning in the event of a default, the secured creditor is going to stand in front of the line, in front of all the unsecured creditors. So that occurs upon attachment. Now, valid security agreement generally travels with the collateral. And again, the creditor's interest in the collateral remains even after the property has been sold. Now, a major exception to this rule is what we call the buyer in the ordinary course of business. We'll talk a bit more about that when we talk about priorities. But in essence, if a buyer is acting in the ordinary course of business, meaning as a buyer in that position typically would, when the buyer purchases goods, even though the goods may be subject to a pre-existing security interest, the buyer takes those goods free of the security interest. So if I go in to an appliance store and the appliance store has secured credit and they have pledged their inventory, if I buy a refrigerator and it gets delivered to my house, that refrigerator was subject to the security interest, but because I'm a buyer in the ordinary course of business, I move to the front of the line. I go in front of the secured creditors. A buyer in the ordinary course of business can take those goods free of any pre-existing security interest. And again, this often arises in inventory. Property that's subject to a claim of inventory, and then Once it's sold, the buyer in the ordinary course of business can take it. This case is actually an interesting case. It's really sort of an exception to this rule. It's a case involving a lender, Morgan County Feeders, and a borrower, Mr. McCormick. Mr. McCormick was a rancher, and the lender had extended a loan to Mr. McCormick, and in exchange for that loan had taken a security interest in all of McCormick's inventory. Now, at the time, Mr. McCormick owned a small herd of longhorn cattle. McCormick sold the cattle to a third party, and the lender objected to the sale because they didn't get paid, and because arguing that the third party is not a buyer in the ordinary course of business, because they took all of the herd. They didn't just take what was necessary for a sale, for a harvest of a sale, you should argue. So what happened is the third party, however, argues that this herd was not subject to the security interest because the security interest was in inventory. And the claim was this herd of cattle was not being used in the normal manner that a rancher would keep cattle. This cattle were not intended to be sold for food. Instead, they were being used in the conduct of essentially a dude ranch in which tourists would want to come play cowboy for a while, and they would conduct this small trail drive and would use the same cattle over and over and over again. So interesting case, not something that we see ordinarily, but it is in your book, and I thought it was an interesting case to talk about. Perfecting a security interest. Now it gets a little bit tougher. What is perfection? What do we mean when we say perfecting a security interest? This is a legal rule. Now, a secured party wants to have priority over other secured parties who may have overlapping security interest in the same property. A borrower can pledge the same property to different creditors as collateral. The burden on those other creditors is they will take a secondary role to any pre-existing security interest. So how do you, as a lender, a secured lender, who is seeking to maintain priority, how do you protect yourself? Well, the law gives to those lenders the ability to protect their priority by accomplishing what's called perfecting the security interest. Perfecting the security interest gives to that lender priority over other secured lenders. Which means for you, the basic rule as a creditor is you cannot simply rely on attachment, because attachment is not going to be enough. You must perfect that security interest that has attached. Because the way the law works is that the first party, the party with priority, gets to take all of the money necessary to satisfy its debt before anything else is left over for secured creditors who don't have priority. So if I am owed $100 and I sell property that is worth $150, I get my $100 back, and then the secondary lender can take whatever is left. And if there's any more after that, the third lender can attach. So obviously you, in the position of a creditor, you want to be first in line. You want to have priority. And that's why I actually devoted a second lecture topic specifically discussing priority. Now there are four main ways to perfect a security interest to protect from any overlapping claim. And the first is perfection by filing. This is the most common type of perfection. And when a party obtains a security interest, when a creditor takes that security interest, what they are to do is to file what's called a UCC-1 financing statement. Now, there's a copy of the UCC-1 in your textbook, and the UCC-1 is used throughout the United States, including Louisiana. And the way it works is that when a lender takes that security interest, they will now file that security interest with generally the Secretary of State where the borrower resides. So typically, Secretaries of State are in charge of this. I do want to point out that Oklahoma is an exception to this rule. In Oklahoma, the UCC-1 is filed with the Oklahoma County Clerk office. The reason for that is when Article 9 was adopted in Oklahoma, the Secretary of State's office did not have the necessary resources to handle the logistics of these acquiring financing statements. And so it was shifted to the Oklahoma County Clerk's office. In any event, once the financing statement is filed, that is notice to the world that you have interest in this collateral. You have interest in that collateral. And because of that, if you are a lender and you are concerned whether collateral has been previously pledged to another lender, you go to conduct a search of the UCC-1s in the state where the borrower lives. And if it comes up there, then you are put on notice that someone else has a superior interest in that property. Now, these financing statements typically last 5 years in most states, and they can be renewed. And as a matter of fact, for many creditors, staying on top of when the financing statement is to be renewed is very important, because if the financing statement is not renewed, then you lose your place in line. You lose your priority. So we perfect security interest in goods, equipment, inventory, and financial products, with the exception of deposit accounts, in this manner. We file a UCC-1 financing statement. And again, this is done for things like patents, trademarks, and copyrights as well. So perfection by filing. It's one way to perfect a security interest.